My name is Kumari Pooja, and I'm again here before you to discuss about legal updates. And I'm also assuming that our live session helped you with the with all the queries that you had with regard to the legal updates. Yes, because I was receiving quite a good amount of questions, and I'm sure I understand the kind of curiosity that you have. Ki kyun kar rahe hain? I mean, why are we doing these legal updates, right? So until unless you do not understand why something is being done, you do not get fascinated about it, right? So that was very, very important. And if you have not watched that video, please go and watch that. It's there. It's still there in our channel. And yes, so let's start with our next set of legal updates. I have quite good, interesting updates from last month. Of course, legal updates are always mostly, things keep happening in India. So we always have something or other very interesting areas to touch upon, right? So let's start with the very first one, which is anti-defection law. If in case you have rectified all the schedules, yes, for your legal static by now, if you have done that, you would have come across a word under 10th schedule that talks about anti-defection law. Now, what is that? So basically, this is a law which prevents a particular minister or a member of a party to change the party. So basically, a dal badlu should be punished. That's what law says in a very informal way. Okay, so if you are changing your side, please be ready for certain penal action against you, right? So what is the controversy that is going on? It is a controversy regarding Maharashtra. Every year you'll see this, okay? जहाँ पे जब भी election होगा, कुछ ना कुछ इसके regarding controversy होती ही होती है, almost all the time. So this has become a daily routine for newspapers now. Yes, idhar kabhi udhar, the people keep doing that. But again, that is not our mudda. We are not going to focus on who is doing what. We need to focus on constitution, right? That's what we take care of. I mean, that is what we are all focused about, right? So no matter which party is, which member is changing his party to which party, of course, that is all politics, not good getting into that, talking about anti-defection law. What has basically happened, it's not our concern, this is our concern. Basically, what law says about it, what is anti-defection law? As the word suggests, anti and defection. Yes, so basically, if you defect a particular party that you belong to, so there's a party ensures that there has to be certain stability in the government, right? And if you are defecting that party, defecting means anti-defection, means if you are defecting that party, if you are going against that, right? In that case, there shall be certain action that has to be taken. So Constitution has given certain provision with regard to that under 10th schedule. Right? Now, what is it about? First one is, if you are leaving one party and joining the other party, in that case, you will get a punishment. That is first. Second is, if you are you have got a ticket from a party and voluntarily, okay, not out of force, but voluntarily, you leave that party, you leave the membership of that party and go to the other party, or you vote for something that the entire party is against. So basically, law believes that if you're a party, if you belong to a party, the entire party should unanimously come to a particular decision, right? So whatever you are voting for, that should be a unanimous decision. Now, in that case, if there is a member, right, that is going against it, right, he or she is choosing to vote against what the entire party is choosing, and that too without any permission. He has not taken any permission. He has not got any consent from the other party members. In that case, that would be amounting to defecting a party, right? Next one is about independence. So now there are certain members, so there are certain people who fight election independently. They do not belong to any party. Now, if in the due course of election, if they change their status from being independent to joining a party, that case also would be a case of defection, right? But there is this little slight leeway has been given to nominated legislature. Means who nominated, he has not been elected yet, he is a nominated legislator. In that case, if in case he wants to change the party, he has time of 6 months. If he wants to do anything of that sort, please go ahead, do it within 6 months. If it exceeds 6 months, you'll again be considered to be defecting the party, right? So that is what is it about. And there's this exception also. It basically says that, basically it allows a group of people, if there are around two-thirds of people in a particular party, people means MPs and MLAs, if they wish to join with other party, with another party, and in that case, it would not amount to defection. Okay? Two-thirds is a huge majority, by the way, okay? Just consider your class, the class that you are studying in your school, and consider two-thirds. If you want to get a majority of two-thirds of your entire class to convince them to get to your team. Yes, so it's not something which is simple. So when we are kids, in that case, when it becomes so complicated situation, just imagine what would happen when there are a lot of politics that are going around, right? So this is a very nice safeguard also, right? It has positive, it has negative also. Basically, I believe the reason here, if you, just in case if you have this curiosity, ma'am, why two-third, why exception has been given here also, defection though is taking place. But the thing is, if majority of the people, right, they are not in consonance, or they are not in the same line with the state's vision, right? Sorry, the party's vision for the state or for the country, right? In that case, if they want to merge with some other party which are in consonance with the vision that they have for the party or for their governance, in that case they can go ahead and they can join the other party, right? There have been certain judgments, very important. First one is Kyoto-Holohan case. So basically, these judgments are around the power of speaker. So what happens whenever any anti-defection case happens, no, in that case, speaker's role is almost highest, I would say. Right? Law has given a lot of powers to speaker, because speaker is the head of that assembly. Now, matter goes to speaker, and whatever the speaker would decide, that would be final and binding on the member. Right, so that is what in 1992 in Kyoto-Holohan case it was said, that it should be the discretion of speaker to decide whether an MP or an MLA has to be disqualified or not. Next case was in 2020 about Nawab Rabia case, so wherein it was said that speaker cannot decide on the disqualification when a notice has been already received by the speaker about his removal. So if there is a proceeding that has already started for the removal of that speaker, in that case, such speaker cannot decide on the disqualification of any member of the parliament or the legislative assembly. And the third case, again, very important, wherein it is said that there's this 3-month period is given to speaker to decide whether disqualification has to be taken place. Otherwise, if मन करा तो फिर तो 3 महीने का 3 साल ले लेंगे speaker and there would be no decision. Right? So there would be instability throughout the party government, में instability. So this time period has been allocated to the speaker. This has been, you have to stick to this time period of 3 months. Right? And they are also proposing to establish a permanent tribunal to hear these cases, because now these cases have become so frequent कि इसके लिए अभी अलग tribunal की जरूरत पड़ने वाली है. Okay. Now, next is something that I'm sure you would have heard a lot about it, and a lot of people talk about it also. Every now and then you would see one article in the Hindu, right? कोई ऐसे writer होते हैं हमारे जो जिनका favorite topic होता है, and if they do not get anything, they would definitely talk about this particular section. It is about hate speech. Okay, so section 153A of Penal Code is about hate speech, right? So we have been witnessing since, with a lot of frequency these days, since quite a few years now. So what is hate speech basically about? That if you would Google it, you would find a lot of complex definition. If you get to the legal explanation of it, again, it will be very complicated. So in a very simple way, hate speech means if you are saying something which is spreading or which is promoting hatred or enmity. And hatred and enmity means not on personal grounds, but on the grounds of, say, faith, of religion, of language, right? Basically, which is the basis of our country. In that case, if you're causing any enmity, that would be considered to be against the maintenance of peace in our country, because that cause instability in our country. And that is what section 153 of A of IPC talks about, right? Hate speech. Now, yes, so how do we, I mean, why this becomes important? Because every now and then we keep seeing people saying something about the religion, attacking somebody else's religion or faith or language or place, right? All of this. And these things keep happening, especially among public functionaries, right? So that's why this hate speech situation has taken a stage right now. And if you would see, the conviction rate of the hate speech is quite low. Quite low means there are a lot of cases that are being filed, but conviction, when it comes to conviction of such people, it's very low, right? So the rate has, I mean, the rate of hate speech has increased, but the conviction has reduced in these cases. Now, what are the safeguards that has been provided by the Supreme Court or by the law with regard to this? First one is Supreme Court has given a judgment wherein Supreme Court has said that whenever we are deciding about hate speech, a person is spreading or promoting hatred or enmity, means what? There has to be certain intent. So that intent of the person shall be established in the case, right? Not only that, under Article 153A, there has to be a prior sanction that has to be taken from the government before initiating any such prosecution. So before starting such trial, such permission has to be taken from the government. आप ऐसे ही बस hate speech करके केस नहीं फाइल कर सकते हो हर अगले day पे. Okay, so since this has become one of the tools for people to, attack other people, I mean, get them arrested and, false cases, all of that. So that's why this safeguard has been given. Another case is Arnish Kumar versus State of Bihar, a recent case, 2014 case, where its report has laid down certain guidelines. Guidelines means whenever a court is deciding on the hate speech, there has to be certain guidelines that has to be followed in order to decide, in order to determine whether it amounts to hate speech or not, and whether it should amount to any conviction or not. Okay, so just because a person has been seen saying something does not mean that he or she has to be automatically arrested and the investigation should automatically start. Okay. Yes, next is seat covered jurisprudence. So basically, this case when we saw decisions that was being given. Adani case, you must have heard about it. So in the Hindenburg's case, the government sent a sealed document to the CJI, and CJI refused to sealed confirmation. A proposed committee went into Hindenburg's report on the Adani, and that sealed situation was there, and it's CJI refused to covered this practice. Okay. In Supreme Court, right? Supreme Court or sometimes lawyers also, they receive certain information in a sealed format. Means a document that would be sealed in an envelope that would be enclosed. So only when the person to whom it has been sent to, only when that person receives such sealed document, then only such document can be opened. Yeah, this is to ensure that only the person who has been intended to get that, only that person gets to read that document, right? So, and this has, there's no such particular law about it, right? But there has been a mention, a slight mention under Supreme Court rules of 2013 and Evidence Act also, a slight mention of it. So we just need to understand what is it. We need not get very much deep into it because the jurisprudence can go a bit deeper here. So we need not get into that. Yeah, हमारा काम है newspaper में आया. Okay, Supreme Court got a sealed suggestion from the government. What is that sealed sealed cover thing, right? That's what we are intending to understand here, and that should be the only case here, right? Need not get into depth. Next is Article 356. Now, recently the Prime Minister, we heard our Prime Minister mentioning that there have been certain misuse of Article 356, right? So what is it basically about? It is about the failure of the constitutional machinery of the state. When state government fails to maintain the constitutional scenario in the state. ठीक है, तो in that case what happens, the president presides over. अभी उस time पे state government bye bye and president hi. Okay, so that's what happens. President comes over the seat, and president is the one who runs the state for a certain period of time. Now there is certain laws with regard to that. It's basically state emergency. So there are certain laws pertaining to that. One of them is that it should happen only for 6 months, not beyond that. Okay, uske aage, even if you want to, if the situation is so bad that you need to extend it, it should not go beyond 3 years. 3 years is huge amount of time, by the way. Yes, so it is only permitted for 6 years, and only in exceptional cases, if the need be, it can be extended till 3 years. But ek baar mein 6 mahine hi aap kar sakte ho, right? And whenever there is any failure of machinery, state machinery that takes place, the matter firstly goes to parliament, and it is a parliament who decides whether president should take over now or not. And it was brought to our constitution through 44th Amendment in 1978, when India was going through a lot of, basically a bad phase for India. So, एक साल से ज्यादा हम उसको एक बार में एक्सटेंड नहीं कर सकते, या एक बार में हम एक साल के लिए ही उसको एक्सटेंड कर सकते हैं. इट कैन बी एक्सटेंडेड ओनली फॉर 1 year एट वंस. ठीक है, मैक्सिमम टिल 3 years, बट एक बार में 1 year. नाउ अनलेस दिस 1 year का situation, I mean this 1 year exception or this provision, it has a certain exception to it also. Means it can go beyond 2 years at a time also if there is a national emergency. Article 352 national emergency. These emergency provisions should be there in your tips. Article 352, Article 356, Article 360. 360 is financial emergency. With God's grace, our country has not faced even a single financial emergency yet. Okay, even if we faced the corona situation, the pandemic, but still there was no ounce of financial emergency yet, which is a very beautiful thing. Something to be very proud of, being been through so much, right? But there have been a lot of instances of national emergency and state emergency. So these provisions should be there in your tips. One of the favorite areas where examiner hits you. तो उतना तो याद होना चाहिए, उतना पता होना चाहिए on what grounds state government and national government, central government, they basically impose these emergencies, right? So there are certain situations. First is when there is a national emergency. Next is when there is extreme necessity to ensure that, or to extend such emergency for more than 2 years, more than 1 year, maybe 2 years or 3 years. Okay, so जब तक बिल्कुल extreme situation ना हो, तब तक you cannot extend it beyond 1 year. एक बार में 1 साल, उससे ज़्यादा नहीं. Okay, now there is this case, SR Bomai case. You will read about this case when you will go to college, and wherein there have been, Supreme Court has basically laid down certain strict guidelines with regard to the state emergency, and for once it was made mandatory for no confidence motion to be passed at the House before imposing such emergency. And these presidential rule also, they are subject to judicial review. Means later on, once presidential rule is done, or maybe when it is in its course, it can be challenged in the court. Judicial review means judiciary can see whether it is going constitutionally or not, or whether president's rule that has been imposed in a particular state, that is constitutional or not. ऐसा तो नहीं कि वो unconstitutional way में किया गया हो, right? There are a lot of controversy that can go around that also. So Supreme Court has, or basically these areas, it can be subjected to the judicial review. Very important area. Okay, judicial review also is an area wherein you can get passages, right? It's also something which is one of the favorite topics of the examiner, right? So yes, that was it for the session today. And as I always say, please, before ending the session, or when the session basically ends, before getting up off your seat, wherever you're sitting, once this video gets over, please sit for 1 or 1.5 minutes, and please think about what all things did we just discuss, right? Just recall it once, and I assure you this will pay you a huge interest by the end of the examination, by the end of this year. You will see, okay, this 1 minute, 2 minutes practice will help you a lot, right? And when you think about it, if you want to revise it, either make a note of it, or you can write it in the comment below. Make a note of it. That note is very important. You know, वो हाथ चलना चाहिए उसमें, कुछ ना कुछ लिखना होता. You should scribble something basically. Okay, your mind gets active with that, and it will help you in your recalling later on. Please do that practice in the comment section below or in your note paper. Just take a note paper, एक paper पे उसको लिख लो, so that you can revise it whenever you come back to this video, okay, or whenever you want to revise it. And if in case you want to revise it, rewatch this video at 2x speed. ठीक है, स्पीड बढ़ा के एक बार मुझे देख लो. आई थिंक आई एम फेयरली स्लो, सो यू कैन वॉच माई वीडियोज with 2x speed also, and you'll get to understand what I'm saying. I believe so. So yes, that would be it from my side, guys. Thank you so much, and all the very best. If you have any question, if you have any query, any feedback, please feel free to put it in the comment section below, and I'll be more than happy to read your comments and answer that.